My name is Joe Whitcomb. I am founder and president of Whitcomb Selinsky PC. We are a veteran-owned and operated law firm situated in South Metro Denver, Colorado. This morning, I'm going to speak to you about a subject about which I get a fair number of questions. It doesn't come up every day, but it comes up regularly enough that I felt like it was worth dedicating a webinar to. And it's on the issue of mergers and acquisitions and the 12 special legal issues that government contractors have to deal with. Now, Whitcomb Selinsky, as a law firm, we do a good bit of government contracting. Most of our clients are veteran-owned and service-disabled veteran-owned small businesses situated around the country. And like any other business, they want to get ready at some point with potentially merging with another company or purchasing another company or selling another company so that they can retire or maybe go on to another venture. So today we're going to talk about 12 issues that are particular to government contractors. Some of them are issues that deal specifically with government contractors that operate in the socioeconomic space, like women-owned businesses, 8As, service-disabled veteran-owned small businesses. You'll hear me use the term SDVOSB or service-disabled veteran-owned small business interchangeably. But we want to cover those issues today. I hope you find the podcast or webinar, however you are getting this information, we hope you find it useful. Again, the 12 issues we want to cover, the first begins with a disclosure of any contractual or regulatory noncompliance that predates the transactions, including violations of the False Claims Act. So put simply, this means if you're purchasing a company, you want to know about any infractions that this company may have encountered. Now, it can be something as small and potentially innocuous as a notice to show cause or a cure notice from a contracting office, which could impact past performance ratings in the future, or it could be something as serious as a False Claims Act violation or a Services Contract Act violation or Davis-Bacon. And you want to know about that because that could obviously impact the company's value down the road. It could impact its ability to engage in government contracting, period. Some of those things could result in debarment if it is found that the owners of the company acted with willful disregard of the law or acted recklessly or acted with an intent to enrich themselves. So you want to as a purchaser, you want to know about it. As a seller, you want to disclose it because that could ultimately impact the purchase price or the selling price of your company. It could also impact that company's ability to do government contracting in the future. The second thing you want to look into is, are there any, as I mentioned, I alluded to earlier, are there any prior suspensions or debarment with the company that you are either targeting or selling? Obviously, the reason that this is important, if you're purchasing a government contractor, you want to make sure that you can still engage in government contracting. And a change in management or ownership does not always or even regularly eliminate the debarment. So you can do some research as simply as looking at sam.gov, looking to see whether there are any listed exclusions for the company that you're purchasing or selling. But you could also ask for representation from the seller or make a representation as a seller that your company has not been subject to debarment or suspensions to your knowledge or under your tenure. That would help at least inoculate you from suit in the future if you're the seller, and it could inoculate you as a buyer from any surprises. If those representations are made, if they prove to not be true in the future, then that would give you some recourse as ability to claw back the purchase or get some of the money that you've held in escrow, which we'll talk about later. You want to know about the company's past performance or disclose the company's past performance, again, if you're the seller, on the current contracts or the contracts that is performed in the past, especially as it relates to the particular area that you're interested in competing. So if you're buying a company that is a jack of all trades, but you're interested in a particular NAICS code in which that company is operating, you'll certainly want to know about any past performance issues as it relates to that NAICS code. If it is a company you're selling, You don't want to wink at any of those past performance issues, shrug them off as no big deal. Better to disclose those and have the buyer know about them and be at ease with them than to face a lawsuit later about a material misrepresentation about your company's past performance. You want to do an analysis of the remaining years and potential accounts receivable income from existing and potentially new contracts held by the business to be purchased. So that's a mouthful. But what you're basically looking for is, where is the target company in its performance of option years or base years? If they are 4 years into a 5-year contract, that will obviously impact the purchase or the value of the company you're purchasing or selling. Because of course, once those contracts expire, they would be subject to competition, and of course, there are no guarantees. Obviously, as I've told many clients, options are exactly what they sound like. They are options. Those options belong to the government to exercise or not to exercise. So be sure you know where those contracts are, and make sure that you value future options for exactly what they are, options to perform. Also look at your accounts receivables on any of those contracts that you're performing. And of course, different contracts have different meanings. If it's a construction contract, it's fair to bet that the company you're purchasing will be allowed to complete the construction contract, just so long as the government doesn't run out of money or the contractor doesn't fail in its performance, and you have some ability to affect that as the buyer or as the seller. But you want to know whether or not the company is being paid on time. Not every government agency pays with the type of regularity that you would hope for from a government agency. So you want to look to see whether or not the company is struggling to receive payments from the government, whether it's had some difficulties with its invoice submissions, and whether the government is paying on time, or perhaps looking for an excuse to cancel this contract for convenience or for cause. You also want to know about any outstanding proposals, or you want to disclose about any outstanding proposals on contracts that you have not yet won. And you want to value those proposals accordingly, understanding that every government contractor who has a proposal submitted has done so in the hopes that they will win, but those hopes don't always translate into reality. So make sure you know what proposals have been submitted, what the value of those contracts are, and whether or not you as the new owner of the company are going to be able to perform those contracts if they are awarded. The relationships that the selling company has may not always transfer to the buying company, and therefore your ability to perform those new contracts may be in question. So be sure to have that investigated. You want to look at the assignment of novation of government contracts from the business being purchased. So novation is a big deal. If you're buying a company's assets, if you're buying the entire company, all of its shares, then novation is not required under the Federal Acquisition Regulation. There may be some verification issues if you're purchasing a service-disabled veteran-owned small business to make sure that you, as the purchasing individual or new LLC members or board members, will still qualify under the CV's regulations for a service-disabled veteran-owned small business, or under the SBA's regulations for service-disabled veteran-owned small businesses. But you want to make sure that novation is going to be accomplished. Novation lies almost entirely within the discretion of the contracting officers. So it's good to have some written representations from the contracting officers that novations won't be difficult, or that they will go through without a hitch. You want to look at the loss of small business or socioeconomic status of the contractor that you are purchasing or selling. So if you're purchasing a government contractor with a relatively low size standard, there are some size standards out there that are, for example, 7.5 million. And that's not a big number in the government contracting space. So you want to make sure that you have reviewed the selling company's financials, make sure you've looked at the top line of their tax returns, and average those out if the company's size standard is regulated by receipts. Now, not every NAICS code in the small business universe is regulated by receipts. Some of them are regulated by the number of employees, but you want to investigate that to make sure that the company you're purchasing is not about to graduate from its size status pursuant to the SBA's rules, especially in the NAICS codes in which you are interested. Now understand that a company may qualify as small for some NAICS codes, but not all. So you want to make sure that you know where that company stands in its socioeconomic status and in its small business status. You want to make sure that any security clearances, secret or top secret security clearances that the company you are purchasing or selling will transfer to the buyer, because that's not a given. So if the business that you as the seller are engaged in involves top secret clearances, then normally the character of the principals, the owners, matters as it relates to the issuance of these top secret clearances or secret clearances. It would be important that the buying company's principals, the owners, would be able to also get at least an interim clearance upon purchase so that they can continue to perform those contracts. And it's hard to know that exactly, but it's good to do some internal searching to make sure that the entities issuing secrets and top secret clearances won't have any reason for pause. So you're looking at things like financial difficulties, bankruptcies within the last 7 years, financial difficulties within the last 7 years, certainly any felonies within the last 7 years would impact that buying company's ability to gain top secret clearances in order to be able to perform. Also, many times facility clearances matter. If there are top secret documents going around, certainly facility clearances will matter. So you want to make sure that all of that is investigated and you're comfortable, or at least some language baked into the purchase agreement that is contingent upon those top secret clearances or facility clearances transferring. You want to look into or investigate or disclose the transfer of intellectual property as it relates to the company you're selling or buying. So that's things like logos, trademarks, trade dress, copyright, patents, certainly trade secrets. You want to make sure that all of that intellectual property, or as much of that intellectual property as you intend to transfer, will in fact transfer. You as the seller may want to hold on to some of your intellectual property. You want to make sure that that is disclosed in your representations and warranties, which is the subject of another video that we've done. But you want to make sure that if you're the buying company, that you're getting everything you bargained for. If there are patents pending, you want to investigate to make sure that those patents have a high likelihood of being issued and secured. You want to make sure if there are foreign patents or foreign intellectual property, that is registered and that those registrations have been adequately policed. Otherwise, you could be purchasing intellectual property that could be jeopardized soon after the purchase. You want to investigate any conflicts of interest as it relates to the purchasing or selling company's ability especially as it relates to government contracts. There may be what's termed an institutional conflict of interest in the selling company's ability to compete for contracts again in the future. If, for example, it had a big hand in the negotiating of or formulating of the RFP, that may run afoul of the company's ability to compete for that contract again in the future. So you want to look for any sort of institutional conflicts of interest that would preclude the selling company's ability to compete again in the future on the contracts that it's performing. You want to look at federal supply schedules, GSA schedules, VA federal supply schedules, to make sure that those federal supply schedules are in good standing, to make sure that they are not about to expire, or if they are about to expire, that you will not encounter a great deal of difficulty in getting those federal supply schedules reissued. Remaining on those schedules could be super important as it relates to your company's ability to continue to perform and make money and thrive. So you want to investigate those federal supply schedules. Typically, an expiring federal supply schedule could take anywhere from 6 to 8 months in order to renew. It's a start from scratch, essentially a start from scratch. The prices that you're bidding are become public and they're scrutinized and investigated by the GSA if it's a GSA supply schedule. So you want to make sure that you are, as the buying company or as a selling company, fully disclosed or you are fully aware of the status of those federal supply schedules. Then you want to look at to see what your the target company or selling company's subcontractor relationships are like. Is their ability to perform tethered to their relationships to subcontractors? You see this very often in general contractors. If you are a construction contractor, now if it's a relationship with an electrical contractor, those may be easy come, easy go. But let's say, for example, the general contract is for the building of a VA facility that was awarded under a SDVOSB set aside, and there are limitations in subcontracting in play. You want to make sure that there may not be a large supply of subcontractors that are also CVE verified SDVOSBs. So you want to look into those subcontractor relationships, make sure those subcontractor relationships are in good standing, make sure the target company has had a good habit of paying subcontractors on time, that the subcontractors have been in the habit of showing up to work on time and meeting benchmarks and deadlines. Those are all things you want to look into. You also want to look into and investigate the existence of joint ventures, teaming agreements. There could be some successor liability as it relates to those teaming agreements or joint venture agreements that are in place, and understand that those are different things. A joint venture agreement, you're forming a different entity, a legal entity. A teaming agreement is, by any other name, a subcontracting agreement. But normally those are government-facing subcontracting agreements. So the government has relied on the existence of this teaming agreement in order to make an award. And therefore, if you're going to replace teaming members, you will need to involve the government, or at least let them know that you're replacing teaming members. Lastly, you want to look at foreign purchases. I'll just put this under the idea of you want to make sure you understand any of the target companies or disclose any of the selling companies' relationships with foreign governments, foreign entities, if it's exporting goods overseas, you want to make sure that its export controls or ITAR compliance is in place. Make sure that it has regulatory compliance protocols in place, because otherwise you could be inheriting a company or purchasing a company that has run afoul of the State Department or is selling goods overseas it's not supposed to. And if you knew about it and did nothing about it, you could inherit some of that company's liabilities. So those 12 things that I've just outlined, again, there will be a written text to accompany this webinar that you'll be able to follow along and use for posterity. Hopefully also we'll get this reduced to a podcast, which you'll be able to resource and use in the future. But again, my name is Joe Whitcomb. I just covered the 12 legal issues of mergers and acquisitions that are not unique to government contractors, but are certainly top of mind as it relates to government contractors. If you have any questions or concerns, of course, we are a resource. We love to be helpful to you.